And so since you guys are going to waste everybody's time even more, goodbye.
Mr. Schuster, you need to sign for your court dates. I'm giving them to you.
Well, the court can say. Let's address.
We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to and give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to. I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio.
Right there. This is one of the biggest misconceptions you'll hear in these courtroom videos. Simply walking up to a microphone or sitting at counsel table does not magically surrender your rights or create personal jurisdiction. The judge is trying to make a clean court record because appeals, motions, and transcripts all rely on audio documentation. But already, you can tell this hearing is about to turn into a full-blown marathon of circular arguments. Y'all think the judge is being patient here or way too patient?
Court record, which is audio recording.
Jurisdiction by doing what you said because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster, I
reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Counsel to me
Well,
without my permission. He has no permission to be my counsel. I'm here sui juris, appropriate persona. I, Jonathan Troy Collins Schuster.
The script.
Under fraud, menace, and duress. I've made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
well, right now,
To answer them?
I am not here to be interrogated by you. You are under the jurisdiction of this.
Going on here.
I think you understand and you choose not to
I do not
take in the information.
understand
Okay, well,
what's going on
Mr.
here.
Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right in my proper. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would,
represent myself.
well, you would. Either you
I
have
don't.
counsel or you are acting pro
Represent
se.
myself. And so, like I have told you, I'm here sui juris appropriate persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction or is this an admiralty maritime jurisdiction?
And here we go with the maritime law argument. If you've watched enough sovereign citizen courtroom clips, you've probably heard references to admiralty courts, gold fringe flags, trusts, and secret contracts. The problem? None of that actually overrides state criminal law in a traffic-related criminal case. The prosecutor's trying to pull the conversation back to reality while he keeps steering it into an alternate legal universe. This is like watching GPS directions fight with conspiracy theories in real time.
Either. So,
Right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I reserve
if you
all
would
my
like-
rights. If you
If
cannot,
you would like,
I will
if you,
step up so you can hear me better, and I will
none of
speak
it's being,
louder.
none of it's being
I will
preserved.
speak
until you-
louder so you can hear me, but
There you go.
I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just
Schuster,
want to make sure the
Mr.
reporter
Schuster,
can hear me.
you are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
So-
begin again so that the recorder can
Not
hear me.
choosing to be silent, you're choosing to make a legal argument. So we need to have that on the record.
For the record, I reserve all rights.
You've made that.
I, Jonathan, Troy, Faifo, Leaso, Maliatoa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international act in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct executing attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
Your Honor, I may be challenging 1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. And the fact that I think it's not that you don't understand, I think it's you choose not to understand and that you have someone giving you information that you
Now,
are
this part is
spewing.
important legally. The court is basically saying, I don't think you're mentally incompetent. I think you're relying on incorrect legal theories. And that distinction matters. Courts can order competency evaluations if someone truly cannot understand proceedings. But misunderstanding the law or refusing to accept it isn't automatically incompetent. Meanwhile, notice how every direct question from the court gets rerouted back to prove jurisdiction. That repetition is starting to wear everybody down.
Information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect
we cannot
that
move
is causing
forward.
you to not be
Defect.
able to
To
understand.
challenge my
computer.
competency because I have challenged the jurisdiction of this court,
We're
and you have
not
not
We're
proved
not dealing
jurisdiction.
in social security or contracts
You
or
have to prove
maritime.
jurisdiction before we can move any further.
So that's just not how it works in this court. And
No,
I don't think
that's
you
how
have
it
the
works.
legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Jennifer, Miss Jennifer, can you
I'm
prove
Judge Grant, so I'm going to
Jennifer,
have
can you
Still
establish the
calling
jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training. So that I think is.
That does not
clear.
matter.
Well,
If I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. Try to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody, and we cannot move further until you've proven jurisdiction.
He's been there for 3 hearings. Well, one he had no choice. The last 2, if she didn't have jurisdiction, then why you keep coming back? I think he has nothing better to do than to argue for nothing.
so Ms. McDonald, think would be the next steps. I don't know if Mr. Parent, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw his.
So we could go through the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Absolutely. I'm just saying, I don't know that he's going to participate in that process either.
Right. No, I understand
We have
that.
speedy trial at
It is the
August
burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter. With prejudice. And I motion to dismiss this matter with prejudice.
Denied.
Based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you. If you'd like.
Like they bought him a. You see how she catered? She's like, it was like she bought him one of those little sippy juices and some animal crackers in a coloring book to sit down.
We cannot move until jurisdiction has been proven.
Yeah, that should be a.
You have failed to prove in
This
jurisdiction.
is the moment where the judge quietly explains something crucial. Jurisdiction challenges are normally argued through legal motions and facts at trial, not by repeatedly interrupting the hearing every 30 seconds. And honestly, you can see the courtroom shifting strategies here. They've stopped debating him and started focusing on procedure, scheduling, and preserving the record. Translation? We're moving this case forward whether you agree with us
Failed
or
to
not.
prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
Right. So Mr. Schuster, did the court say that was end of August or?
It was August 9th is speedy trial.
Okay. So.
And if you plan on having me back here, you're taking away from my ability to provide and work. And I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom court available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
Does the August term start August 6th, Your Honor?
They're ignoring him now.
So I would request we set it during August term.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you.
Yes,
You
they
are subject to
You have
another court, and they could very well.
Get in trouble, and you have to prove jurisdiction. You haven't done that, and you failed to do
Obviously,
that
you
over
believe
and
that
over and
courts
over
do
again.
have
And
jurisdiction
so, I mean,
over you.
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is. And this is just a waste of time at this point. So whatever you need to do to prove jurisdiction, but I know you can. So if you want to waste more of everybody's time, go ahead. Because obviously, I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into cap.
That sounds like the zoo or something.
And that's ridiculous for what's going on here. That's absolutely ridiculous.
Captivity.
I don't think
This matter
anyone
needs
is
to be
told that you're
dismissed
being
with
put into
prejudice.
captivity.
And whether we need to take this to trial or whatever y'all need to do to prove jurisdiction. I mean, go ahead, but obviously you can't prove jurisdiction. So
So I'm looking for the more
waste everybody's
detailed
time, please.
council
Waste everybody's
waiver.
time. It's absolutely ridiculous.
I don't know that he's done that yet,
No, he hasn't. I have a streamlined version, but I want him the formal,
the detailed one.
the detailed one.
We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this council.
Oh yeah.
And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines.
Ms.
And so
Jennifer,
your rights need to be
have-
protected.
Her-
This is for your
nobody-
benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. And I won't stand for you violating my rights.
Oh, what are you gonna do?
Did y'all catch that laughter? Because the tension in this courtroom is turning into straight-up disbelief at this point. The judge is trying to explain that appointing counsel in criminal cases is meant to protect defendants from accidentally hurting their own case. Meanwhile, he sees every procedural step as evidence of corruption. It's two completely different realities colliding in the same courtroom, and neither side is backing down an inch.
If you're going to acquiesce, then okay, you're proving that you don't have any jurisdiction.
So this is a detailed advisement, should you wish to waive your right to have counsel present and you want to act as your own attorney.
I said over and that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel. If you,
I'm here of my own right in my proper person.
Proper person.
You know what that means.
so there's the form.
I've
for you
never
to-
signed my power of attorney away to anybody, especially this.
You need to be respectful.
I-
You are really out of
I
line,
said
Mr.
this. I
Schuster.
didn't say anything disrespectful.
You are respectful.
You
To
were
the
being very
court.
disrespectful, actually,
the court
because you
and to Mr. Parent.
you're violating my rights.
So I'm
forcing
going
me-
to set
Oh.
this on for the
Come in here.
August term. I'm going to have you take this form.
Wasting my
Uh-uh.
time.
Mr. Schuster.
When you're taking away my
I'm going-
ability to divide and work. Because
Have a
this is
seat there so
free-
you can fill out
free
this
place.
form.
You taking a picture
What's
of it?
that?
You can have a seat there so you can fill out the form.
You taking a picture of it?
You're dismissed. Do you need anything else?
Yes, I
Uh-oh.
do. I need you to take that form. So we're going to have to go through that because this case is going to be going to trial. It's going to be set on the August term. That would be August 6th, and that will be at 9 a.m.
All right, you're dismissed.
No, you're
Whoa.
not free to leave yet, Mr. Schuster.
I'm not free to leave.
Not yet.
Why
We're
am I
still
not free to leave?
Because we are still addressing your matter.
This matter needs to be
Yeah,
dismissed.
it's not going to be dismissed right now. Right now, it's getting
Dismissed
set
with
for
prejudice. You cannot
trial.
move any further until you prove jurisdiction.
And the readiness hearing will be July 31st, and that will be at 2 p.m.
don't
And
have
that
any-
hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench.
So, Mr. Schuster, if you
Over
choose
and over
not
and
to
over.
come to your court hearings, a warrant will
Over
issue
and
for
over.
your
And you're
arrest.
threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous.
Captivity.
Absolutely ridiculous.
Yeah, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous, Ms.
we need
Jennifer.
your presence to appear.
Absolutely ridiculous.
All right, let's get a court date form for him.
Absolutely ridiculous.
What's the date for the intervening pre-trial?
There are tissues back there?
We can set a pre-trial. Let's do it on the 22nd. Perfect.
Prosecuting attorney also needs to provide any contracts that I've entered into internationally,
Here's your court date. Could you
Uh,
please sign? for that?
especially if this is a admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So
Mr. Schuster, you are in a criminal court and there are court rules. If you wish
criminal
to
matter,
have,
this is a criminal matter, you said?
Mr. Schuster,
This is a criminal matter?
if you wish to have discovery, then you need to abide.
Criminal matter?
Yes, and if you wish
Yes,
to have
it's a-
Oh, okay. I wasn't sure you said that. Thank you.
criminal matter, if you wish to receive discovery, then you will need to make.
What is the jurisdiction? Are we under an admiralty maritime jurisdiction?
No, we are not. Mr.
Are we under
Schuster.
a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery,
Under
then
jurisdiction.
you need to request,
I gave you my permission to be under that jurisdiction, which I haven't.
you will need to request discovery to his office.
I'm not a U.S. citizen, American national. That's not a jurisdiction.
He just talks
If you
over
wish to
them.
have discovery, you need to request it in writing from the prosecutor's office and we will
You said your
send you.
nationality was a U.S.
And then we,
Is that what you
and then
said
we will,
earlier?
and then we will send you the discovery, of all of the evidence that we have against you at trial.
He doesn't want it.
Did you understand that?
I don't understand what's
Okay.
going on with this.
So-
This is ridiculous.
Here's my
Kangaroo
suggestion,
court.
Mr.
Absolutely.
Schuster.
Kangaroo
Mr.
court. And so
Mr.
since you
Schuster.
guys are gonna waste everybody's time even more, goodbye.
Mr.
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 Schuster, you
Schuster.
need to sign for
my
your court
goodness.
dates. I'm giving them to you
Have
orally.
a good day. Bye.
If you don't appear for hearings that were given today, a warrant will issue.
He don't care. He's leaving. Wow.
And there it is, the dramatic walkout ending. But legally, this is where things get serious. Once the court verbally gives you a hearing date on the record, ignoring it can absolutely lead to a bench warrant, whether you agree with the court's authority or not. The wild part? After nearly 20 minutes of arguing jurisdiction, the case still moved forward exactly the way the court intended. So now I gotta ask y'all, do you think he genuinely believes these arguments work, or is this more about refusing to recognize authority altogether?